Hello and welcome to the second part of this series of talks on public access scheme and appeals. In the first talk I said that what you'll need is the order of the court or tribunal. The court or tribunal generally issues two documents. One will be the order. Now that's the thing that triggers the time limits, which we're about to look at. And then secondly, the reasons for the order or the judgment. And it won't necessarily issue them at the same time. But what you need to appeal is the sealed order of the court or tribunal in order to appeal. So this is the thing that is stamped from the court or tribunal giving the date on which the order is officially made. So let's look at time limits for appealing. I'm looking at the civil courts or tribunals, and it is important to note that the time limits may vary for different tribunals, but the general rule is that you've got 21 days in which to appeal. However, that's subject to any enactment which sets out special provisions for any specific type of appeal. So if your claim is based on a piece of legislation, it may make different provision for the time in which you can appeal. So check the statute that your claim was concerned with. Practice Direction 52D in the Civil Procedure Rules gives special directions for the many statutory categories of appeal, and it's worth having a look at those quickly at the start of your determining whether or not you're going to appeal. The point about statutes is that they may prevent the court from allowing you extra time in which to start the appeal, because the statute will determine whether or not there's any discretion to be applied. So it may, for example, prevent the Court of Appeal remedying procedural errors or dispensing with the need for the person appealing to serve documents. So as I say, do check the statute. Where do you find the rules? The Civil Procedure Rules Part 52.4 says that if you seek permission from the appeal court, you've got to request it in the appellant's notice, which is a document that I'll talk about in a minute. Now, you have to file that notice at the appeal court within whatever period is directed by the lower court, and that period may be longer or shorter than 21 days, which is the norm. Or, if the lower court doesn't make any direction of that nature, saying that you've got a particular period of time in which you can appeal, then the default position is that you've got 21 days after the date of the decision of the lower court that you want to appeal. Unless the appellate court tells you otherwise, the notice has to be served on every respondent, so those are the opponents, your opponents below, as soon as practicable, and in any event not later than 7 days after your notice is formally received by the court office, so after you've filed it with the court. That rule doesn't apply if you're seeking permission to appeal against an interim injunction refusal under Section 41 of the Police and Crime Act 2009. Look at the statutory time limits that are referred to in Section 4 of Practice Direction 52D, which deals with specific types of appeal. One question you should ask yourself when trying to determine whether or not to appeal is whether or not the appeal is in fact academic. So is it going to make any difference to the outcome between the parties? Is it simply on a theoretical proposition of law, which has no practical impact. The Court of Appeal can hear an appeal if all the parties consent, even if a dispute's been settled by the time of the hearing, which of course would normally render an appeal academic. And you and your opponents have to tell the Court of Appeal if the appeal becomes academic. Remember that you appeal against the order, so if you successfully get the order, but you lost an earlier point, then you're unlikely to be able to appeal. So what do I mean by that? Well, suppose there's a jurisdictional question for the lower court, and you say there's no jurisdiction, but the court finds there is, and then on the facts of the case, on the merits of the case, it finds in your favour and makes an order in your favour. Now, in most situations, you won't be able to appeal against that sort of decision. However, if it's an important point on jurisdiction, then the Court of Appeal may decide to hear it if, for example, you are a government department, which this is going to affect in many different cases. The other point about appealing against the order is that you can't appeal until you've got the order, even if judgment's given before it's sealed. The other, perhaps surprising thing is that you don't need to have been a party to the proceedings below. The definition of appellant is broad enough to allow a person who wasn't a party, but who is going to be adversely affected by the outcome. Now, before one gets too excited about this, the courts are very much against people being busybodies and intervening in other people's cases. So bear in mind that the requirement is that you should be adversely affected by the outcome if you're going to be able to get yourself joined as an appellant. You don't necessarily need the judgment. It's the reasoning which leads to the order, and you can start an appeal without it. If you haven't got the judgment, you should start the appeal, generally speaking, to stop the clock, but then ask for the process to be stayed or stopped while you wait for the judgment. What you can do is write to the Court of Appeal office or to the appellate court asking for additional time in which to present your grounds of appeal, or perhaps the appeal itself, so that you can make the points you need by reference to the judgment. Remember that in some cases you may have to rely on the notes that people took at the time of the judgment. If you didn't obtain permission to appeal before the lower court or tribunal, then you have to include an application for permission. So, in other words, if you didn't ask the lower court, or if you did ask the court but lost on the point of permission, then you have to ask for permission in your notice of appeal.